Well, hi, everyone. Thanks for joining us. We'll get started. Thanks for joining us. This webinar is hosted by the Reclaiming Appalachia Coalition on coal reclamation and bankruptcies on post-SMCRA mines. That's the Surface Mine Reclamation and Control Act. Really appreciate all the partners from the coalition joining us. I'll introduce those folks in just a second, as well as Erin Savage, who's going to be giving the main presentation today. We are recording this webinar and we'll post it on our coalition website, reclaimingappalachia.org. And we will be doing a Q&A discussion session at the end of the webinar via the chat function. As I mentioned, Erin Savage is my colleague at Appalachian Voices. She leads our Central Appalachian Impact team and has become a SMCRA expert and has been doing a lot of research into the emerging bankruptcy crisis that she'll be going into during the webinar today. So thanks, Erin, for all your hard work and for joining us today. Also on the webinar from the coalition is Marissa Lotzenheiser from Rural Action, Jacob Hanna from Coalfield Development Corporation, and Joey James from Downstream Strategies. They will be around during the Q&A session in case there's any state-specific questions that they can help answer. So I've got just a few introduction slides about the coalition and how we got to this point, and then I'll turn it over to Erin to get into the meat of the webinar today. So the Reclaiming Appalachia Coalition is a regional coalition with state organizations based in Virginia, West Virginia, and Ohio, as well as coalition partners in Kentucky, Alabama, and Pennsylvania. We have published numerous reports now that are available again on our coalition website, reclaimingappalachia.org. And these reports have projects, innovative reclamation projects, mostly that are funded through the Abandoned Mineland Pilot Program and represent what we hope is a new wave of reclaiming and redeveloping communities impacted by coal mining in Central Appalachia. Our coalition goals are to, a main one is to identify, develop, and implement innovative reclamation projects. In the past, we've been around for about 3 years. Most of our work to date has been on pre-SMCRA pre-SMCRA mine sites, those that existed prior to the passage of the Surface Mine Reclamation and Control Act in 1977. But as Erin will go into detail today, there's a growing need to start looking at those post-law mine sites as well. But a main purpose of our coalition is to help develop those innovative reclamation projects. A new goal for the coalition is to build support for policy priorities around post-law reclamation liabilities resulting from these coal company bankruptcies. That is new for this coming year for the coalition and in a direct response to the crisis that Erin will be going into. And then finally, kind of foundational to our coalition is supporting this community of practice around innovative reclamation and just transition to help community-led development in and beyond Appalachia. So in a nutshell, it's moving our region's coal mining related liabilities into community assets. We use the term innovative reclamation a lot. These are 6 principles that our coalition developed to help describe what we mean by innovative reclamation. Essentially what we mean is going above and beyond the legal requirements of reclamation, ensuring that community benefit or economic development are included in those reclamation projects, and that those project concepts are rooted in real community needs and are led by the communities that they impact the most. We also talk a lot about just transition. What that means for us is that the communities and the individuals and workers that gave the most to power our nation through the coal-based economy of the last century should be among the first to benefit from the new economy that's emerging now, and that transition won't happen without deliberate and thoughtful intervention. And so what we're doing today with this webinar and our whole coalition is part of trying to make sure that transition happens and be a part of that positive intervention for our region. A few words about how we got to this point as a coalition. As I mentioned, we started out working primarily with abandoned mineland pilot funds, which are funds allocated through Congress to state reclamation agencies annually. That's kind of money that's out there and available now. But as we have gotten deeper into that work, we have realize, and as this growing bankruptcy challenge that Erin will go into, it's just becoming more and more apparent that while the pre-law challenge remains, there's just a tremendous growing challenge around these post-law mines. And so given our coalition's strengths and our ability to pivot, it's really important that we start working on these post-law mines, as well as continuing our work around abandoned mine land reclamation as well. So at this point, I'm going to stop sharing my screen and turn it over to Erin. Thanks, Erin, again for sharing your research with us.
Yeah, sounds good. Let me take a second and see if I can get this going. All right, can y'all see that first slide?
All good.
Great.
Oh, it went back to, yeah.
There we go. All right, good now?
Good now.
All right. Yeah, so thanks, Adam. As Adam said, I'm Erin Savage. I am the Central Appalachian Senior Program Manager at Appalachian Voices. I've been doing this work with App Voices for almost a decade now. And up to this point, a lot of my work has focused on issuance of new coal mining permits and impacts of active permits. But over the last year or so, a lot of my focus and the focus of my team has shifted more towards reclamation, both as mines wind down and also as we've started to identify this potential problem with bankruptcies, bond forfeitures, and basically whether there's going to be enough money to reclaim these mines. So right now, the presentation that I'm giving is my research up until this point, which is somewhat preliminary. It is currently focused on Ohio, West Virginia, Kentucky, and Tennessee. We would very much like to expand that at least to other Appalachian states, maybe the whole country. But it's a lot of work and a lot of data collecting. I just wanted to also mention, I know Western Organization of Resource Councils has done a similar analysis on some of the Western states. That's definitely worth a read if you want to find out more about what's going on out west. All right, so Adam went over this a little bit, but what do we mean when we say post-law sites? We mean sites that are post-Surface Mining Control and Reclamation Act of 1977. So mines that are currently permitted under that act. So SMCRA did a lot of things, a lot of good things, and two things that are really important and important to the work that we're doing here. One is establishing the Abandoned Mine Land Fund to address mines that were abandoned prior to passage of the act. And then SMCRA also required coal companies to begin securing reclamation bonds for their new permits so that, at least in theory going forward, we wouldn't have abandoned mines again, and we wouldn't need a continuation of the Abandoned Mine Land Fund for any permits that were created post-law. So how exactly does this happen? Basically, the requirements of SMCRA incentivize coal companies to do the reclamation. They're required to get bonds that can take different forms, and I'll go over that really briefly next. But essentially, the coal companies want to recoup the money or property that's serving as their bond, or they're upholding an agreement with a third-party bond provider such as a surety. So basically, they want that bond money back in some form. But also they reclaim their mines to avoid penalties from the regulators. If they don't keep up with their reclamation, they can get additional fines, and regulators can use other enforcement tools like refusing to grant new permits or stopping their ability to mine or sell coal. And then if all of those incentives fail, then the regulator can fall back on bond forfeiture proceedings, which is basically claiming the bond that the company put up. So at that point, regulators can take over a permit and receive money that would fund the reclamation of that permit. So I'm not going to go into too much detail here. I think the main point with this is that bonding is complicated. States can use alternative bonding that can take a few different forms. And the main issue here is that not all bonds are created equal. Generally, full cost third-party bonds are the most secure, but in many states, companies may use collateral bonds that could take the form of property or equipment, which is not easy to actually liquidate. Or kind of worst case scenario, some companies are self-bonded, and in that scenario, there basically is no money. It's the company's word saying that they're good for the money should they forfeit the bond. Several states in our region also use pool bonding, where essentially part of the bond is covered by a state pool that's paid into by multiple companies. And so that pool pools the collective risk of the permits taking part in it. All right, so not news to anyone. I think at this point, we are looking at a precipitous decline of the coal industry. We saw a first major wave of bankruptcies back in 2015. And at that time, the companies that were going bankrupt were largely able to reorganize and or sell their permits to other coal companies that wanted to take over those permits, and in many cases continue mining coal, and in some cases basically just do reclamation. So at that point, bond forfeiture was fairly rare. Forfeitures happen state to state each year, but it tends to be just a few permits and not a lot of acreage. But now, as we're seeing more companies go bankrupt, we also have fewer companies that are willing or able to take over the mining permits from those bankrupt companies. Let's see. So we haven't at this point seen widespread forfeitures out of bankruptcies, but we are seeing it play out actively now, mainly through the Black Jewel bankruptcy, which I'll talk a little bit more about later. So looking forward, it's really difficult to know how big this problem is going to get, and that is due to a few things. First, certainly some coal companies will still successfully reclaim the permits that they currently hold, but we also know that some companies will not. Like I said, we already know that's happening with Black Jewel. We also have some information on the total amount of reclamation needed, but it tends to be very coarse data. So determining the cost of that outstanding reclamation is pretty difficult. But basically, that's what I'm trying to do here. So I'm going to get into the meat now of the analysis that we've done so far. The first thing that we did was request reclamation data from state and federal agencies. So all of the states that we were working with the exception of Tennessee, where the Office of Surface Mining oversees SMCRA, they keep track of acreage per permit. And each state does it a little bit differently. So we had to create a system where we were trying to compare apples to apples. But the basic breakdown was that states provide data on total disturbed acreage on current permits. And then a subset of that disturbed acreage is reclaimed, but not fully reclaimed, not released from the permit or released from their bond. So generally speaking, that partially reclaimed acreage tends to be acreage that is regraded and reseeded, but hasn't been fully revegetated, probably hasn't had their sediment ponds removed, and maybe has other infrastructure that needs to be removed. So we determined that there was a total of 486,000 acres of currently disturbed acreage on active mining permits. And by active, I don't mean necessarily actively moving coal. I mean that the SMCRA permit still exists. Of that 486,000, 118,000 acres were just categorized as disturbed, meaning that they have little to no reclamation completed. A caveat there is that SMCRA requires contemporaneous reclamation. So companies are supposed to be actively reclaiming as they mine. So that 118,000 acres probably does have some reclamation complete, but we don't have a way to really know exactly what that entails. And then the remaining 368,000 acres fall into that partially reclaimed category, where it's likely been regraded and reseeded, but has not been released from bond. All right, so we also requested information on bonds at the state level, and that is highly variable. And so sorry, I've got my chat window in the way of my legend here. All right, so the green areas are the green columns are basically the permit specific bonds. So in most cases, those are third-party surety bonds, but they may also be some form of collateral bond, which in Appalachia is usually some sort of actual like financial bank-based instrument like cash, certificate of deposit, something like that. Virginia still does have self-bonds in place for one company, A&G Coal. And then the yellow bonds, or the yellow bars, are the pool bonds that exist in Kentucky, Ohio, West Virginia, and Virginia. West Virginia also has a water pool bond that funds long-term water treatment. So an important thing to understand here is that not all bonds are available to all permits. So the permit-specific bond, as its name implies, applies to the permit that it was secured for. So in most cases, you can't shuffle that money around to other permits. The pool bonds apply within the state that the pool exists in and applies to the permits that are taking part in the pool. In some states, Virginia, for example, not all permits take part in the state pool. All right, so the third part of the question here is estimating reclamation liability. And this is definitely the most difficult part. States generally don't have a widespread estimate of reclamation liability. It's very time and data intensive, and there's a high degree of variability between sites. So in order to get a really good estimate, you would need to send inspectors to every single permit and determine what reclamation it would entail there. So how much high wall is there? How much backfilling will be needed? Are there long-term water treatment issues? How many ponds would need to be removed? So it's really difficult to get that liability estimate, and essentially, as far as we can tell, the data doesn't exist on a wide scale. So instead, we looked at a few potential data sources that we knew of that might give us some idea of what that estimate might be. So one is an OSMRE oversight document for Kentucky's bonding program that was completed in 2010. And that oversight document includes a breakdown of liability at 5 permits where it really goes through the details of what those permits could cost, and you can come up with essentially a per acreage or a per acre estimate. Similarly, we looked at the GPRA acre estimates for AML sites for just the 5-state area that we're currently working in, as well as the cost data. The AML inventory is a great and extensive inventory, but it's not a perfect comparison to post-law mines because of time differences, changes in mining techniques, scale, types of problems, and so on. The third data source that we considered was a data set from the Virginia Department of Mines, Minerals, and Energy. And it was a set of worksheets that estimated liability specifically for a set of A&G coal mines in that state. So we ended up going, at least for now, in our draft version with the DMME estimate. Not only did the per acre cost fall right in between the estimates based on AML sites and the estimates based on Kentucky's oversight document, but it also just does the best job of representing the type of mining, surface mining that we have in the region. It is the most recent. It was done in 2016, and it includes a lot of fine granular data like amount of high walls, number of ponds, and things like that. So based on those worksheets, what we did was I broke out the mines that still required major backfilling from the mines that did not require major backfilling. The reason we did that is reclaiming large high walls tends to be a huge part of the reclamation cost for any particular mine. So based on those breakouts, we came up with an $11,000 per acre figure for the partially reclaimed acreage, so acreage that likely doesn't need major backfilling. And then a $16,000 per acre figure for the unreclaimed acreage. And that $16,000 figure we got from all of the mines, not just breaking out those that required major backfilling. So based on those two figures and applying them as you see here for the partially reclaimed acreage and for the unreclaimed acreage, we came up with a total of $5.9 billion for outstanding reclamation in the 5-state area. So just a few notes and comparisons on that number. From a few slides back, the amount of bonds that we have across the 5-state area is about $1.5 billion. So clearly less than the outstanding costs. You know, in an ideal world, that wouldn't be a problem because in most scenarios, the responsible coal companies would be reclaiming their permits and not relying on those bonds. And that may still be the case in many instances, but we already know it's not going to be the case everywhere. Also, just a comparison to AML costs in the 5-state area, we broke out the current estimates for unfunded AML, funded AML, and completed costs. And interestingly, it works out to about the same amount of as the Post-SMCRA costs. All right, so I wanted to real quick go over a couple of situations that we're currently dealing with. They're relevant because these court documents essentially give us access to more information about potential liability and any shortfalls. So first I want to talk about the Black Jewel bankruptcy that is ongoing and has impacted a number of states, but in particular Kentucky. Kentucky has a lot of individual permits held by Black Jewel and its affiliates. And you know, interestingly, Black Jewel, they kind of came about through purchasing permits out of previous bankruptcies. As a result of their bankruptcy, the Kentucky Energy and Environment Cabinet did an estimation of reclamation liability at 20% of the Black Jewel permits in that state. And they determined that the reclamation liability exceeded the available bonds by $38 million. So that, in theory, if those mines were abandoned, that bonding shortfall would fall to the Kentucky state pool. Currently, the debtors have presented a liquidation plan that includes basically leaving 45 permits unsold. And the plan proposes moving those permits into a reclamation trust funded by the surety bonds. And that situation essentially bypasses the SMCRA setup that would allow bond forfeiture and would allow those permits to rely on their existing surety bonds. So we do have concerns about this move to kind of bypass the existing SMCRA setup. We're seeing something similar with ERP Environmental in West Virginia. Again, that company purchased a lot of its permits, really all of them, through the Patriot bankruptcy. At that time, the estimated liability, reclamation liability at those mines was $230 million. We believe that the liability is about the same because ERP didn't get a whole lot of reclamation done in the last few years. And those permits have $115 million in bonds available. So clearly another massive shortfall there that would likely fall to the West Virginia pool. So instead of pursuing bond forfeiture, the West Virginia DEP pursued receivership for that company to basically avoid forfeiting those bonds. So looking forward, it's still really unclear how widespread bankruptcies and mine abandonments will be. Ideally, we'll see a lot of coal companies take responsibility for the reclamation that they owe. It's also very difficult to do anything about the current bonding situation, given the precariousness of most coal companies. It essentially may be too late for many companies to increase their bonding amounts. We know that sureties and state pools are at risk from widespread abandonment, and we're seeing that play out, at least in Kentucky and West Virginia. We're also concerned with this trend of moving abandoned permits outside of the structures of SMCRA. And we think that it is highly likely that Appalachian states will need additional funding sources for reclamation beyond what's currently available through the bonds. So reclamations for next steps. We would like to do a similar analysis for other areas of the country. We would like to improve upon this analysis if we can get additional data. We welcome help in any and all of that. We would love to do some analysis like this really across the whole country if possible. It would be helpful to be able to get more and better data from state and federal agencies regarding bonding, outstanding reclamation needs, and reclamation costs. We would like to identify short-term policy changes that could increase the likelihood of reclamation being completed by the responsible coal companies. We'd also like to identify additional sources of funding for bond shortfalls while still holding companies accountable. And we would like to figure out how communities can be more involved in outcomes of reclamation projects, especially in cases of bond forfeiture where states may become responsible for what reclamation looks like, who gets those jobs, and how the land is used in the future. And that's all I've got for you. So I'd like to, I think, turn it back over to Adam, and we'll open it up for discussion and questions.
Yeah, thanks, Erin, so much. Just want to commend Erin for just the incredible amount of research that has gone into what she shared with y'all today, and just the rigor that she's been approaching these questions is just really amazing, and really, I think, shows through the day that she presented. So thanks, Erin, for that. While we've got questions coming in, just a few points I want to make from the coalition's end. So the substance of what Erin just shared today will be a standalone kind of mini report that will be included in our coalition annual report that we plan to release in mid-January. So be on the lookout for that. We may release it a little bit earlier than that, but it'll definitely be included in the main report in January. And then, as Erin just mentioned, we hope to do a more in-depth analysis next year that answers some of these unanswered questions that Erin just posed, and then has policy recommendations about how we go about fixing that. And our real hope there is that that effort is, we are joined by existing and new partners as we explore how we really tackle this challenge that is certainly regional, if not national, in scope. So it looks like we've got a couple questions coming in. Erin, can you access those questions? Do you want me to pick them out for you? Oh, you're muted.
Yeah. I think I have to stop sharing my screen to see them. So.
Okay. The first ones that should be easy. How often are bonds used in the reclamation process?
Yeah, not often at this point. Sorry, I had to grab my water. This is the most I've talked since coronavirus started. So OSMRE does annual oversight reports for all of the states, and that actually contains really good information about bond forfeiture that's happened in the state for that year. We've looked at that, glanced through it. I haven't compiled data on it, but generally it might be like a few permits and maybe as much as 1,000 acres total. So it's not that common so far, but it does happen.
Cool. Have you gotten to where you can see the other one, Erin?
Yeah, and then I can see Roy's question. Short answer is I don't think that's true anymore. The 2010 oversight document I mentioned also resulted in Kentucky really overhauling their bonding system. In most cases, they can get some portion of their bond back depending on phase 1, 2, and 3 release. Oh, sorry, and I just got a reminder, I need to actually read the question because you guys can't see it. So the question is, many years ago in Kentucky, a coal company could begin reclamation, and by the end of their first year, were eligible to receive 90% of their bond. Is my memory correct? So it's saying that is not the case anymore. They do receive some money back depending on phase 1, 2, and 3, but it's not dependent on like the timing first year. It's depending on meeting the milestones required by phase 1, 2, and 3 release. All right, next question. Ooh, a little PTSD on this one. So will the stream protection rule, which was proposed under the Obama administration, have a chance of coming back and making a bigger impact on the coal industry? I am not a lawyer, but my understanding is no, due to the Congressional Review Act, which bars future administrations taking up the rule again or taking up a substantially similar rule. I think lawyers will have to decide what substantially similar means.
All right, looks like that's all the questions we've got in the queue right now. Oh, one just came in from chat. Can you see that one, Erin?
Get to it. All right, this question is, do we know of any other international experience with bonding or coal reclamation as the coal industry has declined in other places too? Very good question. Yes, but that my understanding is not strong. I think it's possible that looking to Germany comes to mind, also the UK, but I know there are differences there in terms of how much those regions' economies relied on coal mining and how governments handled their laws and how the wind down occurred. I don't know the details of those. I know others who do, others who've researched that, and that would potentially be a good area to look for policy recommendations. All right, next question. Is there a regional lobbying effort to attract national attention? A Green New Deal could involve repurposing reclaimed spaces for sustainable industries. Adam, maybe you and I can share the answer to this, if you want.
Yeah, you want to start? You want me to start?
I'll start. So
okay.
In terms of national attention, yes, there are groups working on this. It tends to be kind of ad hoc coalitions. So there's a good kind of East-West coalition working on the Black Jewel bankruptcy. And one of the things that we've really tried to do is publicize what's going on there and raise concerns. I know others are doing that around other bankruptcies as well. We also just hosted a 2-day-long summit on essentially policy recommendations for the Office of Surface Mining Reclamation and Enforcement, much of which centered around bankruptcy and post-law reclamation. So those efforts are underway, but in some ways also just getting started. So still a lot of room for participation and for input and visioning and things like that.
Yeah, and I would just add, that in 2021, our coalition hopes to play, a role in that, bringing together of those different efforts that Erin just mentioned, and that we hope that the ongoing research that we're doing can help provide some, really data-based, how bad the problem actually is, and then what we can do about it based on that, better understanding. So, we're looking to next year to be, hopefully a significant shift from where we are now to the end of next year.
Yeah, one of the things one of the bright spots in an otherwise difficult situation we're facing is that there may be more and better opportunities for communities to have input on how land is reclaimed and where those jobs come from, what those jobs look like. More ability for that than we've seen up to this point.
Yeah, I want to see if any of the other coalition partners have any thoughts on that. Not to put you on the spot, but. Okay, fair enough.
Adam, yes.
Hey, Joey. Welcome.
Yes, I have some thoughts.
Joey James of Downstream Strategies in West Virginia. Hi, Joey.
Hi, yes. No, Adam, I just want to just note, the research that you all have done at App Voices, that Erin's done, it really shows that we need double the money that we currently have to address the, extensive environmental liabilities that exist. And we know that there's already problems with the AML fund and, how it's taking care of problems. And so, I hope that the work that we are doing as a coalition in identifying innovative reuse opportunities for these pieces of property, help make these sites more accessible for other types of capital, because I think we're over-reliant on, there's an over-reliance on public funds to take care of a lot of these issues. And the innovative economic development opportunities that we're exploring, really hopefully model opportunities for private investment on these sites that can be used, to take care of some of the environmental liabilities as well.
Yeah, thanks, Joey. Okay.
There's another question.
Go for it.
So this question is, when an unbonded coal company declares bankruptcy and abandons its mines, are they no longer liable to reclaim the land? The theoretical answer to that is that there is no such thing as an unbonded coal company. That was what SMCRA intended, and therefore there wouldn't be an abandoned mine because the bond would cover the reclamation. However, I think probably the most accurate example here would be a coal company that is self-bonded. So that company, they basically have only given their word that they're good for the money. So there is no bond held by a third party or by the state, by a bank, anything like that. So that's the closest we have to an unbonded coal company. And at this point, in my opinion, it essentially is an unbonded coal company. In that case, if that bond was forfeited, some of those are participating in state pools. So there may be some money available through the state pool. But other than that, SMCRA does, at least in theory, allow state regulators to take legal action against companies or the officers of the company to try to recoup any shortfall in bonding costs or in reclamation costs. So it is possible to recoup that money, but it's likely very challenging. Corporate law is a messy business.
All right. Not seeing any other questions in the Q&A or the chat roll. Are you, Erin?
Nope.
Okay. Great. Well, any other thoughts from you, Erin, before we wrap up?
just happy that everyone took part. You know, this is a big challenge, but it's kind of new and exciting. I want to find good opportunities, and we're really, really looking for input from other people, for resources, for help doing more analysis, and help kind of pressuring our state and federal agencies to collect more data that will help us really get a handle on this problem, and be useful for you know, telling our decision makers what they need to do next to help us solve it.
Great. Well, Erin, thanks so much for sharing your awesome research. Really appreciate it. Thanks to everyone for joining us. Again, our coalition website is reclaimingappalachia.org. Our contact information for all the coalition partners is there, as well as many webinars and other reports and other resources. So encourage y'all to check that out. I hope everyone stays safe out there and have a happy holidays. Bye.